Hi again, it's me, Citizen Gumshoes, and I have another docket today on Mr. Combs again, and I just wanted to try and recite it without my glasses on, so you best bear with me, hadn't you? Okay? Alrighty then. Sean Combs faces enormous challenges in this case, not because of evidence, but because he must defend himself and prepare for trial from jail. Then most people, I don't know what the pre-trial custody status is associated with ultimate outcomes of the case. With released defendants consistently faring better than defendants in jail in detention, ABA standard for criminal justice pre-trial release. But if that weren't enough, the government exploited Mr. Combs' detention by engaging in unfair, unconstitutional tactics that have interfered with his ability to work with his attorneys and make it impossible for his attorneys to provide effective assistance for counsel. The evidence shows the government is using Mr. Combs' detention to spy on him and invade his confidential communications with his counsel. Since his arrest, the government has been working with Bob staff, including Investigator 1, to take advantage of his incarceration by meticulously monitoring all his communications, including with his attorneys. And during a recent BOP sweep of MDC, Investigator 1 illegally searched Mr. Combs' handwritten notes containing privileged communications and work product. Investigator 1 photographed the notes and then shared them with the prosecutors. Prosecutors claimed they did not request this search, yet they conceded Investigators 1 has been investigating Mr. Combs at their direction all along, gathering evidence they have used and hope to continue using against Mr. Combs. This disturbing conduct is a blatant violation of Mr. Combs' rights. Prosecutors' search was motivated by security concerns at MDC, but that is a false pretext. The purported purpose of the BOP sweep was to search for contraband, but since when is prison contraband photographed and left in place? If it were contraband, it would have been seized. That is not what Investigator 1 did here, leading to the inescapable conclusion that this was an intentional targeted illegal search to discover any information that could give the prosecutors a leg up against Mr. Combs, including his handwritten privilege notes, a roadmap to his defense, that an investigator working with the prosecution team specifically to investigate Mr. Combs in the MDC would use a agency search of the facility as a ruse to surreptitiously spy on Mr. Combs' defense camp is outrageous. No legitimate penological interest motivated this conduct. If the government is seriously contending otherwise, it would call to stand the lead of official from the US Bureau of Prisons or whatever agency was in charge to explain how the unlawful targeted actions that violated an inmate's 4th, 5th and 6th Amendment rights were contemplated by and within the purview of the BOP sweep in MDC. The government's illegal actions do not end there, however. Immediately after the search, Investigator 1 debriefed the prosecutors. That's a little bit bent, isn't it? They had a clear opportunity to remedy the misconduct. But instead, they doubled down. The prosecutors knowingly, intentionally, and secretly took possession of the notes and then used them against Combs. They took the notes without following the agreed upon filter team procedure that is supposed to ensure that the case team is not tainted by access to privileged information. They then appended clearly privileged portions of the notes to their bail opposition to support continued detention. And it is impossible to know what else the government has done with the notes. Indeed, the prosecution has refused to disclaim using the notes to further its investigation going forward. This entire sequence of events, even based on the facts known to date, is shocking and outrageous government conduct. The government has intentionally violated Mr. Combs' attorney-client privilege and Sixth Amendment right to counsel by invading defense camp and unjustifiably interfering with his relationship with counsel and his ability to defend himself. Mr. Combs cannot possibly receive a fair trial if he is not permitted to confer privately and confidentially with his counsel and others working at their direction, and to take and keep notes of his trial preparation. The search also violated the 4th Amendment and Mr. Combs' 5th Amendment due to process rights. This court intervention is imperative to safeguard Mr. Combs' constitutional rights and the ability to defend himself against these very serious charges. Because the government has proven time again that it will intentionally continue to violate those rights if given a chance. It's that RICO charge, isn't it? Once that's on you, it sticks. This is the same prosecution team that provided the doctored, misleading CNN video tape to 3 judges while withholding more accurate footage to keep Mr. Combs in jail. This is the same prosecution team that seeks to distance itself from Homeland Security agents who leaked false and damaging statements to the press. This is the same prosecution team that has repeatedly alleged that a sex trafficking victim without having even spoken to her, and now they are deploying Big Brother tactics and an illegal search of the defence camp. If this represents the office's traditions of doing the right thing the right way for the right reasons, then Mr. Combs' only chance at a fair trial is immediately judicial intervention. Sorry. We request discovery and hearing determine the extent of the violations, to establish procedures to minimize prejudice going forward, and to ensure that Mr. Combs receives a fair trial. The court should also order other necessary relief, including but not limited to 1. Suppression of the notes and any fruits of illegal searches. 2. Directing that a special master conduct privilege review in lieu of the filter team going forward. 3. Disqualification of any and all prosecutors tainted by access to privileged materials. 4. Ordering the government to stop monitoring Mr. Combs' communications with the defence team. And 5th, defending on the evidence adduced at the hearing at dismissal of the indictment. Background. A. Investigator 1. Investigation of Mr. Combs. While Mr. Combs has been detained at the MDC, BOP staff, including Investigator 1, have inconsistently monitored the defendant's communications on monitored communications channel. Throughout these monitoring efforts, Investigator 1 was focused on Mr. Combs in an investigatory capacity, as he was tasked with reviewing the defendant's calls and emails. The government was particularly interested in Mr. Combs' communications as part of what is described as continuing ongoing converting of investigations into the defendant's obstructive conduct in the MDC. It therefore requested material from Investigator 1, who turned over materials including Mr. Combs' calls and emails in response to grand jury subpoenas and document requests. B. October 28th to November 1st, 2024, BOP sweep Investigator 1 search of Mr. Combs' legal notes. From October 28th to November 1st, 2024, the BOP conducted a sweep of the MDC. It was purportedly pre-planned and coordinated as part of a larger safety and security initiative, and not in response to any particular threat or intelligence. The prosecutors knew in advance that Mr. Combs' unit would be searched during the sweep. The government's representation of what occurred during the sweep, which Combs disputes, is as follows. Investigator 1 was signed by Bob to participate in the sweep and was presented at the MDC during the operation. The government claims that during the sweep, Investigator 1 interviewed multiple inmates, including Combs, about potential corruption and contraband at the MDC. Investigator 1 then searched Combs' area for contraband. He found none. And then he encountered a manila folder marked, as well as an address book and several legal pads that the government characterized as a single blank. According to the government, Investigator 1 set aside the manila folder and then reviewed the photographed the blank. Yeah. On December 3rd, 2004, at 4:01 p.m., the government produced a subset of materials obtained from Bob, to which the case team has access. That subset contains thousands of pages of emails and Bob documents that the defense team is in the process of reviewing. Again. Sorry it's taken so long, but it's what we have to do. Notably, the government story diverges in significant respects from the defence's understanding of events. First, it is not clear to the defense that Investigator 1 is actually an MDC employee. Wow. For example, the assistant warden at the MDC has since represented that Investigator 1 is not anyone under his command, and the agent who interviewed Mr. Combs during the sweep was not based in New York. Second, the notes at issue were not stored on Mr. Combs' bunk, but were stored in his locker, meaning the government's description of the chain of custody of the notes is incomplete or inaccurate. And finally, the defense has been told by Bob guards at MDC that they do not carry cameras or cell phones, and it is not unusual policy or procedure to do so, or take photographs such as the ones taken by Investigator 1. Sounds really wrong, doesn't it? The government's description also lacks critical details. For example, the legal notes at issue are not limited to the notes Investigator 1 successfully photographed. Rather, among the stack of legal pads were other papers that Investigator 1 would have seen, papers that would have given Investigator 1 a preview into Mr. Combs' entire defense strategy, his thoughts and impressions regarding the evidence and charges, and other classic examples of work product. Investigator 1, for at least one of these notepads, raffled through 7 pages of material. It's a bad thing to happen, this. You could be thrown out for this. Prepared at council direction to photograph 1 to 2 of Exhibit 1. The government has not described the full extent of Investigator 1 communications with them and what, if any, additional privileged material was conveyed. Even if this information was not shared with the prosecution team, it is still known by Investigator 1, a government agent working to advance the investigation. Yeah, sounds corrupt as fuck. The government cannot describe the full extent to which Investigator 1 might have reviewed but not photographed these privileged materials and orally shared what he saw on these pads, because it knows it could not legally have access to this information. C. Investigator 1 alerts the government, which ratifies the illegal search. According to the government, following the MDC sweep, Investigator 1 alerted the prosecutors that he had taken photographs of defendant's notebook. I remember reading that one, yeah. Investigator 1 described its contents, although it is not clear how or to what extent Investigator 1 shared this information with the prosecutors, or which prosecutor specifically. The prosecutors then asked Investigator 1 to provide photographs directly to the filter team. It is not clear if the prosecutors subpoenaed the photographs from Investigator 1 or whether Investigator 1 simply shared them upon being asked. At the time of the prosecutors requested the photographs, they understood there was a possibility that they touched legal strategy. Possibility that they touched on a legal strategy and could be privileged. The notes were then shared with the prosecutors after a review by the filter team. The filter team did not withhold any of the materials from the prosecutors, but merely applied de minimis redactions to contain limited content in the notes. Prior to sharing the redacted notes with prosecutors, the filter team did not provide any copies of the notes to the defense team, departing from the parties' prior practice and agreement. D. The government uses the notes. On November 15, 2024, the government filed its opposition to defendants' renewed bail motion, which stated the trial prosecutors possessed possibly privileged materials such as the notes recovered from defendant's cell. The opposition cited excerpts of two such notes. I can't see that. It's my phone, it's cracked. The opposition said that the government had listened to Mr. Combs' calls, including with family members and his attorneys. 2. Reviewed his messages with dozens of individuals, including attorneys. Until receiving the government's submission, the defense had never been notified of these facts and was unaware Investigator 1 had reviewed and made copies of Mr. Combs' privileged materials. Mr. Combs' counsel immediately notified the prosecutors the notes were privileged and sought relief from the court. The court ordered the parties to submit letters in advance of November 19th. The government produced copies of the unredacted notes reviewed by the filter team, as well as redacted versions it received from the filter team. Mr. Combs' counsel submitted an ex parte declaration describing why these materials were privileged on November 19th. At the hearing, the government argued that the materials were not on their face privileged and stated it intended to use those notes. It did, yeah. In connection with its ongoing investigation. This is November 19th still. The court ordered the prosecutors to destroy any copy of the notes in their possession and set a schedule for instant motion. I see. The government acknowledged the risk of continuing to rely on the notes in its investigation, but did not agree to refrain from doing so going forward. Communications with the prosecutors in this case suggest that the government has already made affirmative use of the notes, even apart from its bail arguments. Yeah, I brought her up in the bail argument, didn't they? Like, he was talking about ways to bribe and all that in these notes. But they were confidential. You shouldn't have looked at them. But the full extent to which the prosecution has been tainted by its knowledge of the privileged material is entirely unknown. Arguments. Number 1. The government violated Mr. Combs' attorney-client privilege and his Sixth Amendment rights. The government invaded the defence camp to obtain and use materials protected by the attorney-client privilege. Such government interference in the relationship between attorney and defendant may violate the latter's right to effective assistance of counsel and thus the defendant's Sixth Amendment rights. In determination whether the government violated Mr. Combs' rights, the court should consider whether the government intentionally sought to obtain privilege communications and whether those communications were passed to prosecutors in a pending case. That is precisely what transpired here. Such an intentional intrusion warrants careful scrutiny because it violates a defendant's constitutional rights. 1. It is well settled that individuals retain their attorney-client privilege when incarcerated and detained, and even when inmates have a reduced expectation of privacy. In documents for Fourth Amendment purpose, the Sixth and Fourth Amendment inquiries are independent of each other. Thus, memorialization of private conversations an inmate has with an attorney are protected with disclosure by the attorney-client privilege, as is an outline of what client wishes to discuss with counsel, prepared in advance of any such discussion. So he's preparing to speak to his attorney on these notes. And before he gets to discuss that with his attorney, they've confiscated them. Even where the contents of outlines are not subsequently discussed with an attorney, they are protected if they are not conveyed as a consequence of intervening events such as delay. A note prepared by a client at the behest of counsel in anticipation of litigation are also protected by the work product doctrine. Mr. Combs has already made the required showing that the notes cited in the government's opposition, Exhibits E and O, are indeed privileged. They contain memorializations of private conversations with counsel, as well as Mr. Combs' outlines for discussion he subsequently had with counsel. The vast majority of the remaining notes are also privileged or work product. The notes reflect 1. Trial strategy, 2. Opinion material revealing counsel's and Mr. Combs' mental process regarding his defence, 3. The anticipated course of the defence investigation and questions concerning past investigation, and 4. Possible trial witness testimony. The notes also reflect Mr. Combs' thoughts on certain avenues of the investigation and trial strategy prepared at the behest of counsel, because Mr. Combs supports his claim with more that mere conclusionary. I hate Latin. Anyway, he has satisfied his burden of showing that the materials in question are privileged. There is no question the prosecutors requested and subsequently possessed Mr. Combs' privileged materials, violated his Sixth Amendment rights. The prosecutors were put on notice of the privileged nature of the materials when Investigator 1 alerted them to its existence and described its contents. Knowing it was likely privileged, the prosecutors asked Investigator 1 to share the materials through the filter team, never alerting the defense team that the government was in possession of privileged material. And when prosecutors ultimately received the barely redacted copies of the notes, it was clear from the face of the notes that they were privileged. Redacted. But the prosecutors ignored these clear indications of privilege, and they affirmatively used the material in their bail oppositions. They did so while admitting they were currently in the possession of possibly privileged materials. That is the clear violation. Indeed, the Solicitor General has twice conceded that the Sixth Amendment would be violated if the government places an informant in the defence camp during the criminal trial and receives from that informant privileged information pertaining to the defence of the criminal charges. That is precisely what the government did here, through Investigator 1. The fact that legal strategy was conveyed not just to government agents, but to the prosecution team, distinguishes this case from other cases. For example, the FBI agents did not review the papers, but instead gathered the papers for standby counsel, later analysts, never communicating anything from the defendant's papers to prosecution team. August 10th, 2022. There was no Wow, I don't know what that means. It's nothing to do with that date. Ignore that date. And in Weatherford, there was no communication of defence strategy to the prosecution. But here the prosecutors affirmatively requested the material and then used material that was on its face clearly privileged. Really going into this on, well, if he is an informant, that is really bad news for the prosecution and for the victim, you know. The way the prosecutors diverged from the agreed upon filter team protocol is further evidence of misconduct. Under the unusual agreed upon protocol, the defence should have been notified that the government possessed possibly privileged materials and been given an opportunity to view the materials and assert privilege. Instead, however, the prosecution bypassed this protocol and the filter team simply passed most of the material onto the case team. That's wrong. No violation where no evidence that the government intentionally diverged from the protocol, nor was this an instance in which the prosecution received after the fact notice of potential privileged documents. So it wasn't after the fact, it was before the fact, you know. Or acted pursuant to the search warrants subject to judicial oversight. Rather, the prosecutors understood the privileged nature of the documents up front, yet proceeded unilaterally and without caution with the goal of taking advantage of their improper access to privileged materials to keep Mr. Combs detained and try to obtain a conviction. There is no excuse for this blatant disregard for Mr. Combs' Sixth Amendment rights. Although the court rejected the argument that an undisclosed government overhear of an attorney-client conversation required a new trial, it did so only because 1. There was no indication that the defendant's telephone conversations were monitored for the purpose of gaining information to use at his trial. 2. The surveillance was neither authorized nor approved by federal authorities. The court made clear, however, that in cases like this one, where those were the facts, it would amount to a practice it would immediately prescribe with appropriate remedy, including retrial. Of course, the Second Circuit shares the view that surreptitious intrusion by a government agent into the confidential relationship between lawyer and client and other similar tactics are beneath the high standards of professional conduct expected of a government counsel. 2. The government violated Mr. Combs' Fourth Amendment rights. The search and seize of Mr. Combs' notepads also violated the Fourth Amendment. Pre-trial detainees retain Fourth Amendment protections, and our pre-trial detainees' loss of Fourth Amendment rights is occasioned only by the legitimate need of institutional security carried out by objective administrators. Warrantless searches performed at the instigation of non-prison officials for non-institutional security-related reasons are therefore prohibited by the Fourth Amendment. At 24, likewise, warrantless searches intended solely to bolster the prosecution's case against the pre-trial detainee awaiting his day in court, or to uncover information that would aid them in laying additional indictments against the detainee, are out of bounds where such a search is performed. The validity of the search may be challenged and suppression required if the search was not conducted for legitimate security reasons. Federal courts charged with the duty to protect these rights do not fulfill that obligation merely by paying lip service to this concept. There was plainly no legitimate security reason to peruse Mr. Combs' personal notes or photograph them. The government investigator one aims was to uncover information that would aid the prosecution of this case and gain tactical advantages. The stated rationale for the BOP sweep was to find a contraband and evidence of MDC corruption, but the search quickly progressed beyond that limited purpose and became a pretext for an unconstitutional search. No contraband could possibly be found in pages of Mr. Combs' notes, yet Investigator 1 searched them anyway, and he did not stop merely at search for the notes. He then photographed multiple pages of notes so he could share them with the prosecution. Nor was the search carried out by an objective administrator. Instead, it was carried out by a biased investigator collecting additional evidence for the prosecution team. Indeed, the government admits the materials were ultimately received as part of a continuing covert of investigation, the goal of which is to produce evidence supporting additional criminal charges against Mr. Combs. At the time of the search, Investigator 1 knew of the materials would be useful to the prosecution. Photographing the notes for that very purpose and not because of any institutional security concerns related to the BOP sweep. It is no response for the government to pretend Investigator 1 is not a member of the prosecution team. The Fourth Amendment prescribes unlawful searches by government actors. Even if Investigator 1 was not working at the prosecution direction, he was clearly a government actor. Regardless, it is undisputed that Investigator 1 performed investigative duties on behalf of the prosecutors. Investigator 1 was specifically tasked with consistently monitoring the defendant's communications, and he was focused on Mr. Combs in an investigatory capacity, as he was tasked with reviewing the defendant's calls and emails. He did this on behalf of the prosecutors and to their continuing request to collect evidence as part of a government's ongoing investigation. He thus monitored when communications identified helpful evidence and produced it to the prosecution team. He did that prior to the BOP sweep and acted with the purpose during the sweep, which is why he immediately voluntarily alerted the prosecutors that he photographed materials written by the defendant, including notes regarding finding dirt on witnesses. Moreover, upon being alerted of Investigator 1's conduct, the prosecutors immediately ratified it by debriefing him about the contents of the notes and asking him to produce them, even if they did not order the search ex ante. They endorsed Investigator 1's unlawful conduct and used it to further their investigation and detention of Mr. Combs. Third, discovery and a hearing are required. Mr. Combs' rights were clearly violated, as explained below. The appropriate remedy depends on the government's intent, Investigator 1, motivations and extent to which the privileged material has been used to develop the government's investigation. A hearing is necessary to determine these issues and to resolve the dispute factual issues. For example, the government's claim its review needs only be reasonable, not perfect, and says it proceeded here in good faith. But that claim is belied by its insistence, at least prior to the court's intervention, on continuing to use the materials to advance its investigation and prosecution, and the government's account of what happened conflicts with basic information the defense has learned. A hearing is required to find out what really happened and why. The court should not just accept the government's say so, especially because the government's narrative does not ring true. I will finish the rest of this tomorrow. I hope you found this useful and helpful today. Yeah, I'm really surprised by this because it's wrong in every way. It's not helping. It's gonna get worse, this case, especially with so much corruption. The last thing you need is some weird agent lurking about taking pictures of what he's doing. It's just gonna make shit worse. So I'm so sorry that this has happened, especially for Cassandra. I mean, she's the victim. And so is Dawn Richards. that I'm aware of. Yeah, it's very sad. And he'd be clicking his heels if he gets off with this, for sure. And I hope it don't happen, but I swear it seems that way. It's going to get that way with all these silly little incidents and happening. And for the prosecution to see that, that's disgusting. It's not right. It's not right. If he was a white man, would there be this much corruption? Would it be different? I was reading the reply to Rodney Jones' case on Lucian Grange, and he was talking about how RICO charges need two to connect, and Rob Jones doesn't have that in his case. He doesn't have the company doesn't connect with Love Records or something. So Motown Records isn't connected to this. It's a Bad Boys. So it's like they're saying, what's it got to do with us type of thing? But, I'm sure they've got very, very powerful lawyers. I'm sure they've got a lot of litigation help. For this to happen is very, very odd, especially in a federal case. It's a very serious matter, and it could get a lesser sentence for it. And people normally do. So let's see what happens, and I'll read the rest tomorrow. 10 pages left, guys. Take care, guys. Ciao for now. Bye.